The right to practice forestry is one of the most powerful tools we have in South Carolina to limit how counties and towns regulate forestry activities. But it's important to understand that not all forest lands qualify, not all forestry practices are covered, and invoking this law can impact what a landowner is allowed to do on their property for years to come after harvesting. This recent timber harvest almost didn't happen. Initially, the county said this land is not zoned for forestry, but with a little bit of communication and education about the right to practice forestry law, this harvest was allowed to move forward. We're seeing more and more county and town governments shutting down logging jobs and restricting logging trucks. You need to be familiar with the Right to Practice Forestry Act before you find yourself in a situation where you need it. The proper title in the South Carolina Code of Laws is Local Regulation of Development Affecting Forest Land. And the heart of this law is that a county or municipality must not adopt or enforce any ordinance, rule, regulation, resolution, or permit related to forestry activities on forest land. That's very clear and strong language, but where exactly does it apply? First of all, the law covers generally accepted forestry practices, including harvesting, site preparation, tree planting, burning, use of chemicals, road building, and more. To qualify for protection, the property must meet at least one of 5 criteria. The more criteria that are met, the stronger the case for protection. Those criteria are being assessed as forest use for property taxes, have a written forest management plan, be certified through Tree Farm, Sustainable Forestry Initiative, or Forest Stewardship Council, be in a conservation easement, or be in full compliance with South Carolina's best management practices for forestry. At this site inside town limits, the landowner was using a combination of mechanical and chemical treatments to control understory vegetation. That's a fairly common practice in areas where the smoke from prescribed burning can be a problem. In this case, the town shut down the operation and demanded the landowner get expensive landscaping permits. In this case, the right to practice forestry did not apply because there's already a master plan for development in place for this property. Any activity associated with the conversion of forest land to development or other land use will not qualify for protection. The right to practice forestry is intended to protect long-term forest management on lands that will stay in forest use. This ensures that forestry will be regulated at the state level rather than locally. Not only do you need to know the landowner's intentions before you use the right to practice forestry law, the landowner needs to know before you invoke this law on their property. If the right to practice forestry is used, then the county or town may deny any building permit, site development, or subdivision on the property for up to 5 years. The landowner needs to make that decision. In addition to the law itself, we have strong support from the Attorney General of South Carolina. The Attorney General issued an opinion that clarifies application of the law and strengthens our legal position for any case that might be decided in court. Among the Attorney General's conclusions, counties and towns may not require buffers of any kind. They may not require compliance with best management practices, may not regulate the use of public roads or require permits for access to public roads, and may not apply tree protection standards to forestry activities. The right to practice forestry is a powerful tool and not one that we want to abuse or take lightly. Make sure you understand the law and how it may apply in your situation. In most cases, when local governments stop forestry operations, it's from confusion and lack of knowledge. Most local officials are unfamiliar with forestry practices and may mistake logging for land clearing and future development. Sometimes local governments simply want to control land use and collect fees for permits. In a few cases, we encounter the anti-forestry belief that timber harvesting is a harmful practice that simply should not be allowed within their jurisdiction. Sometimes we need to educate our local officials about the importance of forestry for our economy, our environment, and our quality of life. We need to remind them about the scenic beauty, the wildlife habitat, the clean air and water, and other benefits that all come from working forest lands, and that yes, sometimes we need a timber harvest every 25 or 30 years to make it economically viable to keep that land forested. Sometimes we have to fight and take legal action. We have to make sure that any landowner planting trees today will be able to manage and harvest that resource in the future. We need that guarantee to sustain our industry, and we need that guarantee to sustain our forest. I hope this information will help you better understand the right to practice forestry and how it may apply in situations that you encounter.